Hi again, everyone. This is Mark Mavsessian. I'm the co-director of the Center for Law and Religion at St. John's in New York, and I'm joined once again by my friend and colleague, the other co-director of the center, Professor Marc DiGirolamo, for an episode of Legal Spirits, our podcast series on cases and issues in law and religion. You can find past episodes archived on Apple iTunes, also on Android and Spotify and other streaming platforms, and on our website, Law and Religion Forum, that's one word, lawandreligionforum.org. Well, I'm very excited about today's episode. Today's episode is going to be an interview with the person I just mentioned a second ago, Marc DiGirolamo, who is the other co-director of our center. And I'm going to interview Marc today about his new article, which is, I guess, not yet out, but coming out soon, called Traditionalism Rising, which is, I must say, and I put aside all bias in saying this is truly a fantastic article.
Cool.
And
That's
I think
very nice of you to say, Mark. Thank you.
and I think I really urge listeners to read it, because it really is one of these articles that is kind of reconfiguring the field in interesting ways, and it's really something that everybody, I think, who's interested in constitutional law should read. So welcome, Marc. Welcome as a guest this time.
Thank you very much. And this is a nice sort of turnabout is fair play. We had a discussion about your article, and now one of mine. We thought that we would bring to listeners a little something about our own work that we've been doing that is adjacent to and involves some of the law and religion issues that we normally talk about, but is a little bit of something else.
Great. Okay, Marc. So let's begin. So the title of your piece is Traditionalism Rising, which sounds very exciting. And your basic argument is in the paper that in doctrinal areas as diverse as the Due Process Clause, the Establishment Clause, the Free Exercise Clause, the Second Amendment, and others, that traditionalism has become the method of constitutional adjudication. And you say it's mostly conservative justices who have endorsed this, but not uniformly. You say the progressive justices have embraced this method too. So I guess the first question for today is, what is traditionalism in your view? What is the constitutional method that you claim is now taking off at the Supreme Court?
Okay, great. Well, so I think, and just as a little bit of background, this is a general project that I've been working on over the last few years in a number of different papers. And so this latest paper is sort of the kind of culmination of some of these other projects involving what I've described as traditionalism. And I should say also connected to some of our center projects involving the Tradition Project, which is something that we've really been considering, thinking about the role and value of tradition in law, politics, culture, and a number of areas since 2016. So this is a kind of a long-term project that's been gestating, and this latest paper is the latest effort there. So when I say traditionalism in constitutional law, what I'm trying to do is I'm trying to identify, as you say, a method that the court is using now, but actually that it has long used in a variety of areas. The first paper that I wrote about 3 years ago concerned traditionalism across all of the domains of constitutional law, separation of powers issues, areas that you would, Fourth Amendment, Sixth Amendment, and so on. The method is really defined by what I would call three key features. The first feature is a focus on practices, concrete practices, as determining the meaning of constitutional provisions. So, for example, in the First Amendment, let's say in the speech context, we could think about the practice of pamphleteering, right? That's a practice that people have participated in and that has been regulated in a variety of ways. And so these practices, and I call them practices both of regulation, and I'm interested not only in federal regulation, but in state and local regulation, but also of popular and cultural import. So practices that people have engaged in, again, individually and in groups, that I claim have informed the meaning of various constitutional provisions.
Right, Mark, but you're not talking, as I understand it, about judicial practice here. You're not talking about what common law lawyers would think of as precedent, as that kind of practice, correct?
That's correct. I'm not talking about judicial practices, or at least I'm not talking about a kind of common law constitutionalism. I mean, it was, that is to say, as that project has developed in the 20th century. It was once the case, and this is a very powerful conception of the common law, that the common law was supposed to, in many ways, reflect and regulate and kind of organize common practices in the sense that I'm talking about. Uh, Whatever one might say about that project, I think that the present notion of what common law judging is all about is quite different than that, and really concerns judicial law, judicial creation of the law. Um, Instead, what I'm interested in is political and cultural practices, and I'm interested in them in a diffuse way. I want to get a sort of a sense of, or survey the practices in this sense of the country in various states and localities and so on, to see if we can kind of assemble a sense of what, again, political and cultural practice look like. So that's the first feature, a focus on practices. The second feature of traditionalism concerns what I call the issue of endurance. And endurance is itself composed of a number of different sub elements. One of those is age. A simple question: how old is this practice? How far back does it go? A second kind of feature is continuity, the continuity of the practice. That is to say, over time, how long has it gone on in either the same form or in somewhat altered form? But in any event, how what can we say with respect to the sort of duration and continuity of the practice in those terms, right? Sequentially, in terms of years, how long has it lasted? Um, and then the third feature concerns something that I call density. That is, how broadly was the practice adopted? Since I'm interested in a sort of a diffuse examination of the practices, can we trace the practice across many, many different areas to get a sense of how broadly it was adopted? So that's really the second feature. The third and final feature is the issue of the presumptive authority of practices. So, what I say in this piece a little bit, but especially in other pieces, is that we can, looking at these first two components, we can get a sense for what the meaning. We can get a sort of sense of information about what the meaning of various constitutional provisions is, but it's not to say that that sense or that determination of meaning is conclusive. There will be situations in which, for a variety of reasons, including either bad faith or mistake, or some sort of extremely overpowering and broadly accepted moral justification or moral reason, the tradition, what I call the tradition of practice, can be overridden. So those are really the three elements.
Mark, as you described it, it sounds to me a bit like the concept of customary international law, which is a public international law concept, which talks about practices that states engage in from a sense of legal obligation. Now, you don't talk about that last part very much, that people are engaging in these practices because they think that they are legal obligations, but otherwise, it strikes me as similar to that. Okay, so it's very hard to follow this without an example. So let's make this concrete. In your paper, you say that the best example of traditionalism rising is in the Second Amendment context, but we're a law and religion center. So maybe just a quick example, if you could, from the religion clause context of where you see this method presently.
Sure. The probably the best example is actually from a case prior to this term, and that case was called Town of Greece versus Galloway, involving the issue of legislative prayer, the extent to which legislative prayer, which is to say these prayers that are held by legislative bodies, generally to inaugurate or kick off a legislative session, are constitutional and conform with the Establishment Clause. And so, if you think about various ways to analyze that question, you could think about it in a kind of what I call in the paper a principled way. You could say, well, we have this principle of separation of church and state, and as a result, we can reason downward from that principle to find that this particular practice really violates that principle. And so, irrespective of what was done historically or what people may have thought, they just, let's say, didn't see as clearly as we do, or missed it or something like that, what the principle requires. So that would be one kind of approach. My approach is somewhat like the inverse of that approach. My approach is to say, well, the first thing that we need to think about is, did or did not people at the time of ratification engage in this practice? Because what we want to know, again, if we're determining, so there is a kind of a connection here that we'll talk about in a little bit with respect to what is called originalism. But if we want to determine the meaning of the words of the Establishment Clause, um, an important determinant of that meaning is going to be what people actually did. Because as a general matter, what we mean and what we do tend to line up. They tend to go together. Not always, but as a presumptive matter at least. So we look to evidence, for example, about the practice of legislative prayer in the colonies, or we look to evidence of legislative practices of legislative prayer in the first Congress, or we look to practices of legislative prayer just after ratification. So a kind of a constrained time frame gives us our first indication about whether the practice, this particular practice, does or doesn't line up with a law respecting an establishment of religion. But we don't stop there. We actually want to look before, well before, and then well after, because the more evidence of a particular practice's existence and continuity and density, the greater confidence we can have that that practice, in fact, is or is not considered to be part of the meaning of the text. And so we can almost think of it in the metaphor that I use in the paper like a ski slope. What we want, if for those of you listeners who are skiing or skiers out there, what you want is the best kind of skiing is a long slope that is dense and continuous throughout. You don't want it to be sort of marked by giant patches of bare ground. You don't want it to be icy. You want it to be smooth. And so you sort of think about this along a sliding scale. The more of that kind of evidence that one has, the more confident that one can be that the practice either fits or does not fit within the meaning of the text. And I should say one other thing, and that is, um, in determining whether the particular practice under review fits within the tradition, it is permissible, on my view, to think about, and the way that I'd put this is sort of mid-level ideas about what it is that this practice is for in the first place, right? So why did people engage in legislative prayer? To see whether, if we can derive sort of ideas, justifications, and so on for that practice, whether the new thing that we're looking at fits in within this older thing, or is instead something different from it.
Yeah, thank you, Mark. And I'm glad you actually mentioned originalism. I was going to ask about that, but you kind of explained that already. That listeners should understand that from your perspective, and I imagine also from the perspective of originalists, your theory is not originalism because it doesn't just freeze something at a moment in time. It's not positivist in the way that originalism is. Now, some of this I understand, listeners, is inside baseball for con law scholars, but I do think I should mention that Mark, in his paper, discusses the differences between his approach and originalism. So, Mark, as you point out in your paper, most scholars today would find your approach very off-putting. So, how at this particular moment in American constitutional history, how do you justify a traditionalist approach? What are the best arguments in favor of it?
Yeah, and I think you're right about that, Mark. It's probably not going to be at least not an immediately appealing argument or method of interpretation for many constitutional scholars.
Yes, you're speaking for posterity.
I'm speaking for posterity, and I'm hoping to convince at least some people, that there's something worthwhile here. There's sort of two features of this. One, I'm just trying to describe what the court is doing, right? I think that this is a new move. And the second thing is, as you say, I'm trying to offer at least some justifications. And there, I think, one can justify a theory of interpretation at a number of different levels. Um, one could justify it as you mentioned the word positivist, right? And in some ways, I can make those arguments about traditionalism. In fact, I can claim, and I think with increasing credibility, that traditionalism is our law of the Constitution right now. It really seems to be what you can see it in a number of different areas. It's what exists, right? The sort of positive law of the Constitution is in many ways traditionalist. Um, uh, uh,
Well, yes, I was going to say that when I said positivist, maybe I meant textualist. It's not the sense that the law is what the supreme lawgiver, the legislator, has put down in black and white. That's what I meant by
okay,
positive.
well,
Not in the sense that you're not describing what exists, but this other theory of law.
that's certainly possible, right? Another way to defend or justify traditionalism is by arguing that for a people like ours in a democratic republic, it is a particularly appropriate kind of method. And in a different paper, not the one that you read, I call this a populist democratic justification for originalism, because you might think in a democratic republic, the laws gain legitimacy because people believe that they have had a hand in making them, either a direct hand or an indirect hand. And of course, people's traditions and practices are reflective of, oftentimes, I claim, such an understanding of what the law is and what it ought to be. So that's a second possible sort of, how to put it, level of justification. Um,
So it seems to me, I'm over my head here. You do jurisprudence, not me, but it seems like the sort of the German school, right? This is Savigny, which talks about that the law is legitimate to the extent that it comports with the traditions of the people.
Correct. That's right. That would be another kind of justification. A third kind of justification, which actually is the kind that I engage in this paper, is the sort of, it's the broadest, I think, and that justification is there, what reason is there for any legal system to be traditionalist? Not just necessarily ours as a matter of positive law or as a matter of democratic theory, but period, at all. And there, I think, and in the paper, I offer three possibilities. One is based on the idea that um, trying to understand why it is that people generally regret the loss of certain kinds of phenomena in our world, and why they don't regret other kinds of loss. So they regret, for example, the loss of, let's say, that old moth-eaten easy chair, or they regret the loss of certain practices, right, that they engage in, certain, let's say, family dinners, right, or other kinds of social, but they don't regret necessarily the loss of the death of stars in distant galaxies, right? They don't regret the loss of particular ideas that they've held when they've changed their mind. And so I try to say, well, how do we explain this? And there I've got an idea that we regret it. We regret it when social practices that have constituted our lives in various ways die out oftentimes. And the example that I give is, if we had the sense that our practices would die with us when we died, we would value very, very different things in our lives, because we hope and expect, oftentimes, and again, presumptively, that our practices will endure beyond our death. And if that's true, then it's likely that our predecessors thought the same thing. And so that, again, is what I call a sort of desiderative justification for traditionalism. So that's one kind of justification. I have a couple of other ones that I could bore you with. which in some ways are deeper justifications, Mark. But I don't know if you have questions about that one.
Well, no, I mean, I thank you, Mark. I take what you're saying here. I mean, it often occurs to me that, so the generation of students coming up now, everyone says famously, are not into institutions. They're not into traditions at all. And I think institutions and traditions go together. But they're interested in the tradition of craft brewing. We think tradition is good with respect to certain kinds of things, but not others. And it's interesting to ask why that is so. I mean, why do people like the moth-eaten chair? And by the way, anyone who's been to Mark's office will understand the reference there. Personally, I would not at all miss the moth-eaten chair if it goes. But some people care about those things, not others. It's interesting to think about that. In the interest of time, Mark, I want to raise one other issue that our listeners should know about, and that is your paper raises a number of possible criticisms of traditionalism, involving the appropriate level of generality and so forth. But in the interest of time, let's just focus on one of the objections, and here's what it is. Isn't traditionalism like originalism before it? And you distance yourself from originalism, but isn't traditionalism simply a vehicle for achieving politically conservative or retrograde results? And isn't the court's embrace of traditionalism now simply a vehicle for that? Isn't this simply a mechanism for the court to reach politically conservative results that it wants to reach? So, how would you answer that objection?
Yeah, it's a good objection, and it's certainly one that would be voiced by uh, folks who immediately see the sort of political valences of any method. And I, in my it's funny, in my classes in constitutional law, Mark, as well as I also teach tort law. It's interesting to me that students immediately can see the political valences of constitutional law. That it's all law. Sorry, it's all politics with respect to con law, but they're not so quick to see the deep political valences of something like tort law. And so I spend a lot of my time trying to elicit those connections in tort law, and a lot of time trying to sort of show how law-like the Constitution can be.
Yeah, which is just interrupt is very interesting because, of course, 50, 60, 70 years ago, it would have been just the opposite. The realists were very focused on private law, on changing that. And the great sort of progressive legal decisions from California, whatever, were in products liability and various kinds of, unconscionability and so on. So it's interesting. That's the topic maybe for another podcast.
I
Why has
agree.
that
I agree.
why has that switched?
We should do another one on that issue. But I guess I would say, of course, it's true that there are political valences to every method, which is not the same as to say that a method is reducible to its politics. I think that the valences of traditionalism are custodial and preservative. And so, to that extent, the method will oftentimes result in what is conventionally regarded as a conservative outcome, but not always. Not always. And I think here there's sort of a connection to one of the other justifications. It's my view that the practices that we engage in, again, presumptively, not all of them, but the practices that we engage in because they lead to certain kinds of virtues of human behavior. So there's a virtue ethical component to my theory. We do the things that we do politically, culturally, as practices that endure very often because engaging in those practices over time leads us to certain kinds of qualities of character. And those qualities of character, I think, are do not necessarily have any political, ideological valence one way or another. I think about something like pamphleteering, for example, right, which I had mentioned before. Well, pamphleteering does not necessarily have any political valence one way or another. You could be the little guy, you can be someone who is in the minority and engage in that practice and evince certain kinds of political virtues and have those virtues and those practices protected by the court against, let's say, regulation, government regulation that is new, that is trying to encroach on that practice. And you would have a very, very um, uh, it would not be easy to identify exactly where the politics of such a conflict would lie. In fact, I would say that anybody who is um, uh, anyone who is interested or concerned about the loss of valuable ways of doing and being across the ideological spectrum, is going to find something in this method that is appealing to them. And that might very well be, at least in some circumstances, you know, what at least at one time was considered a progressive, perhaps earlier in the 20th century more than now. But I do think you could think of the old left, let's say, as finding some of the methods that I discuss appealing in their own way.
Well, that is very interesting, and there is some movement out there to unite the kind of old right and the old left in some ways, or maybe it's the new right and the old left. I don't know. We'll see if that fusion can work any more than other attempts at fusion have worked. But it's a very interesting thought. Okay, Mark, well, we'll leave it there, I guess. But I do want to encourage listeners really to read the paper because this is a paper that will help you reconceptualize and rethink what American constitutional law is about. And whether you agree with it or don't agree with it, it's extremely suggestive of ideas and really, really worth the time. So we'll leave it there. And until next time, this has been another episode of Legal Spirits, our podcast series on cases and issues in law and religion. You can find past episodes archived on our website, lawandreligionforum.org, but also on streaming sites like Apple iTunes and Spotify and Android and lots of others. See you next time.